Hey everybody, Bobby Klink from Your Online Genius here again. I'm an intellectual property lawyer who helps online entrepreneurs protect their businesses and their platforms and make sure that they are protected, that they're not stepping on legal landmines, that they've got everything in place that they need to have in place, and they can do it all without having to pay someone like me hundreds or thousands of dollars an hour to get it done. Instead, I provide the tools, I provide the resources so that you can do it yourself. So that's what the business is about, and that's what I'm about. Again, this is another video in our series that is addressing basics of intellectual property law. As I've explained in prior lessons, my view is that every online entrepreneur needs to have just kind of a basic working knowledge of the different areas of intellectual property law. The reason is that if you don't even know the basics, you can't even figure out if you have an issue. So you need to know the basics so you can kind of spot an issue and say, hey, there might be an issue here. I need to look into this. I need to do something about it. So that's the point of me giving you the basics and kind of going over it now. In this video, we're going to address the fourth kind of intellectual property. It's copyrights. Earlier this week, we talked about patents, trademarks, and trade secrets. Copyrights is something that I think most people have a general sense about, and most people understand about something generally, but there are a lot of misconceptions about it too. It's an area that every online entrepreneur needs to know about because, quite candidly, it's the area where you have the most of your assets. Most of your assets are protected by it and potentially implicated by it. So you need to have a sense of it. Really, copyright is everywhere. So let's start and let's dive into the lesson then. So we're going to start with a simple question. What is a copyright? Well, copyright is a form of protection of property that is a creative work. So it's the protection for the idea behind a creative work. It's pretty broad. Creative here doesn't have to mean that it's the Great Gatsby or some great work of literature. It just means it's something that has some spark of creativity beyond simply compiling data. So, simply a list of names and phone numbers that had every single name and every single phone number in an area is not a copyrightable piece of information because it's just information. It's not creative. Now, if you organize it in a certain way, if you make some editorial choices, then it gets protection. So that's what creative means in this sense. But let's talk about generally the types of things that are protected. There are four major areas that you should be thinking about. One is any kind of written material. So, obvious, a book, you understand that books are copyrighted, but everything that's kind of written and creative work has some. Then the next thing on the list are images. So still images, photographs. So, oops, wrong way. These photos back here are almost certainly copyrighted work they are copyrighted work that's protected by the photographer has a right in that image. The next thing is any kind of movie. So moving images obviously are the same as images. They're protected. That one you probably get if you've watched a Blu-ray, DVD, VHS tape, or if you're my age or older, a Betamax tape. You've seen the FBI warning at the beginning. And it's, of course, telling you that, hey, this is copyrighted work. And if you were to copy it and distribute it without permission, it's a federal crime. You could also be sued. So we all know that. That's a basic thing that I think everyone knows. And then the final area is music. So any musical work is copyrighted. Now, there are some interesting things here that a certain piece of work can actually have multiple copyrights. And so music is the most obvious example of this. So the person who originally wrote the music has a copyright in it. But then the particular sound recording also will have a separate separate copyright. So again, let's use an example of, if the Beatles originally recorded or wrote a song, they have a copyright in the actual music itself. Then they will have a separate copyright on the actual recording that they did. Now, if someone in the future got permission to do a cover of that and recorded a cover, they will then have a copyright in that cover. So you can have multiple layers here. And that's something that happens with copyright. So what is the importance for you as an online entrepreneur about copyright law? Well, let me put it simply. Pretty much all of your digital assets are copyrighted material. They are all creative works of some form or another that fall within one of those things. So again, your lead magnets are probably written works of some sort. You might have a checklist, a cheat sheet, a white paper, a course, a free ebook. Again, all that's written material. If you have a course, you might also have written material in addition to a recording. So I, for example, have a free course, The 5 Mistakes That Online Entrepreneurs Make That Can Doom Their Business. And it has written work. There's slides. You see the slides and you get an email from me, but you also hear me talking on top of it. And it's a recording on top of the slides. So again, you get the written protection as well as the protection because it's a video. So you can just kind of see when you start thinking about this, that almost everything that's part of your inbound marketing strategy is protected by copyright. Now, if you're also selling digital assets, again, it could be a more in-depth checklist or cheat sheet or execution plan. It could be a course. It could be anything like that. Those will also be copyrighted. And so they have protection there as well. So all of your assets are copyrighted work. So you might be asking yourself, okay, great. Do I need to do anything about it? And the answer to that, no, you don't have to do anything up front. You get protection immediately upon putting your copyrightable work into fixed form. And so that just means, in the case of something written, once you write it down, it's protected. A video, once you record it and it's done and it's in fixed form, it's protected. So all of these protections come immediately. Now, you can also register a copyright, and you've probably seen various people have, things saying they have a registered copyright. And that's a process that requires basically for you to deposit, send copies of the work. I think it's to the Library of Congress, but you can do that pretty simply. It's a small fee to do it. You obviously aren't going to do that with all of your assets, just there's no reason to. The reason why you want to register a copyright at times is that it gives you stronger protection for your work at various times in various ways. So if in the future someone stole your copyrighted material and was passing it off on their own, before you could sue them for copyright infringement, you would have to register the work. Now, you could register the work and then sue them, and that's fine. You don't have to worry about it. Not an issue. But if you've actually registered it within a short period after you create it or before anyone else steals it and starts using it, you would also get certain, really good advantages in a future lawsuit. You basically could get what are called statutory damages. You don't have to prove that you were actually hurt. You can just get a judge and say, hey, I want my damages that the statute says I can get. And a judge can award them there. There are some other small benefits, but quite honestly, except for things like a substantial work, a book. If you have a course, a signature course, that one I might consider figuring out a way and getting it registered copyright. That might be worth doing. But again, you have to make that decision yourself. There's a cost involved. There's a process involved. And really, it only matters if there's a chance you're going to have to sue someone down the line for it. So, that's what you need to think about in that. Now, the other point, though, that I want to make clear, and really the big issue here for most online entrepreneurs, is not so much protecting their own assets. That's important, but luckily you have protection automatically. So understanding copyright doesn't really require you to do anything to get the protection. So that's great. I mean, you don't have to do that. But let's talk about the counter side. That also means that everyone else automatically got copyright protection in their work. So if you go to someone else's website and they have a blog post or any kind of written copy, they have copyright protection that you can't just lift that and use it as your own. Now, again, let me be clear. In copyright, the idea itself is not protected. What is protected is the particular form that it's put down in. So, again, someone can't copyright list building and say, hey, you can't talk about list building. I've got all those concepts in my course. No. It's only the particular way they've laid it out that is copyrightable and gets protection. But again, the point is you can't go and take someone else's thing and just kind of take it verbatim or make minor changes. If you think about back, if you when you were in school, you couldn't plagiarize. I mean, you have to make it your own. You can take the ideas, you can get inspiration from them, but you have to actually put down your own written work, or your own video or your own music, etc. But the same thing with images. You can't go out and, a lot of people say, hey, I'm going to go into Google Images and I'm going to, find an image I want. I'm going to copy it. I'm going to put it on my website. Not a good idea because you do not have the right to do that. Those images are copyrighted works and you are infringing the copyright if you do that. That's why you need to go, there are services where you can buy images, obviously, but you can also go to places like, Pexels or Pixabay, or I think it's StockSnap. There's a bunch of free resources out there where you can get images you can use. Or again, if you want to, buy, you can go to Shutterstock, and some of those on the cheaper end. Or if you really want to go to the top end, you can go to places like Getty Images. And Getty Images, since I bring it up, is an important one to bring up because they are, they're a company that charges thousands of dollars for their images to get a license to it. And so they will, they actively enforce their copyrights. If you were to get one of their images without a license and put it on your website, they will find out about it. And you will get a letter from them and they're going to say, hey, thanks for using our image. We charge $5,000 or whatever the number is for that. So please send us a check for that amount. And if you don't, they're going to come after you. So that's kind of the thing you can do that can get you in big trouble if you end up with that. Another issue that comes up over and over again is music is protected. So what does that mean? Well, that means you can't take music and use it anywhere on your website, in your campaigns, in any kind of product you were putting out there in social media without a license. So that is something you just can't do. If you do, you're going to get yourself in trouble. Candidly, I hear people making this mistake all the time. I'll listen to a podcast. I hear music. I'm like, no. I know that's that's a popular work, and I doubt they paid the money they would need to have actually licensed that. You'll see it in social media videos. If you're on YouTube, for example, sometimes you will see people who are in fact playing music in the background. Again, that's not allowed. If you do that, you are infringing someone's copyright. So you can't do that. Now, the next question is, other than the Getty image example I give you, well, what happens if you actually do infringe? And, what could happen? Well, you could get sued, which that's bad in and of itself. But the other problem is there is, it's called a DMCA takedown notice, and it refers to the Digital Millennium Copyright Act. And part of that law was meant to protect internet companies. So Facebook, for example, or YouTube, or hosting services, your ISP, and, server farms, places who host websites, because there was a concern that they might be, found to have infringed someone's copyright because of actions of people like you or me, right? Because we put something on our site. So that law has provisions that protect those companies, but what they have to do is respond if they get a complaint. And so what does that mean? Let's say you were to take something of mine. Let's say I had some copyrighted music. You were to take it and use it in your YouTube video. And I found that video. I could send a letter or a DMCA takedown notice to YouTube, and they will then respond by taking down your video because you've infringed my copyright. So, if you do it once or twice, you might have a video or two taken down, or you might have something taken down. If you do it repeatedly, what's going to happen is YouTube or any social media account is going to shut you down. Your web host, GoDaddy, for example, might say, we're not hosting you anymore, and kick you off, and so you can't get web hosting. So it can really destroy your business if you do it. So you need to be careful to avoid it, or you could have some serious, dire consequences. So again, that's about it for today. The big takeaway is copyrights are everywhere. They are protecting all of your assets, but they're also creating potential liability if you borrow from someone else. So don't do that. You need to be conscientious to make sure you're not infringing anyone else's works. Again, if you've enjoyed this, I've got my free course that I mentioned on the 5 mistakes that could doom your business. You can find that at mistakes.youronlinegenius.com. Again, mistakes.youronlinegenius.com. You go there, you'll get this 5-part course that walks you through 5 of the biggest mistakes I see entrepreneurs make and helps you figure out what you need to do instead. And then, that's the perfect place to start. So that's all for today. Tomorrow we'll be talking about the right to publicity, which is kind of a fifth different area of intellectual property, but that's what we'll be learning tomorrow. So until then, have a great day. Thanks. Bye.